Morning.
I have all the council here present today. And we have council, we have Mr. Morales as joining us today for Caring Society as well.
It's for Chiefs of Ontario, actually.
For Chief of Ontario, I apologize for
No
Chief of
problem.
Ontario.
Thanks.
Thank you. Okay, I will prompt, we'll start the webinar and prompt the recording. And I will open court.
Recording in progress.
I'll just give it a 30-second mark to the participant to join in. Perfect. Presiding Justice, Mr. Justice Favel, the court is now resumed. Thank you.
Thank you. Good morning, everyone. So we're here beginning day 4, which is dealing with matter judicial review concerning T-155920, dealing with what the Attorney General of Canada calls the definition of First Nations child decision, and others refer to it as the entitlement to Jordan's principle. Just a couple of housekeeping matters before I turn it over to Mr. Frater for submissions. Just wanted to, a small point of clarification. In reply, Mr. Frater referred to my description of Jordan's principle as a program, and I think the tribunal and parties refer to it as a legal obligation, legal principle, rule, and things of that nature. So I was just, and that was in the context of my questioning of the AFN, just in terms of the details of Jordan's principle over the years, from the complaint to where we're at now. So I didn't intend to use the word program. I think it's clear that it's much more than that. And in fact, in his reply, Mr. Frater referred to it as clarified his position and also referred to it as a legal obligation in terms of following tribunal's orders. So I was just trying to be mindful of his paragraph 113 of the submissions and to not weigh in on what is perhaps a different interpretation, I guess. So that's so I'm aware that the tribunal and the parties are referring to it as a legal principle, and Mr. Frater clarified the position as well. That it's a legal rule as well, a legal principle. There, so we'll hear more about it because it's set. That wording is used in the decision CHRT 20 of 2020. So that's point number 1. Point number 2, just in terms of our agenda for the day, we've got the schedule is sets out that the Attorney General is allotted 2 hours, Caring Society 1 hour, and the Assembly of First Nations 1 hour as well. So depending on how things go, I think that might be a full day for us, and so it looks like that's how we can proceed. Day 5 tomorrow looks also like it could be a full day, but with more submissions. So I think if that's what we'll try and achieve today, and we'll see how it goes. So without any further delay, I've eaten some of Mr. Frater's time, so he'll of course be granted additional time. I'll turn it over to Mr. Frater to begin submissions on the First Nations child definition or the eligibility decision.
Justice Favell, if I may, you made brief reference on the first day to the Congress of Aboriginal Peoples doing written submissions only, but the schedule does provide for us to make oral argument as well.
Yes, thank you, Mr. Loken, for that. I looked at the direction that was issued in February and the amended one in March, and it sets that out as well. What you just indicated, that Congress of Aboriginal Peoples has oral submissions as well. So,
Thank you.
Well noted. Thank you. Mr. Frater, the floor is yours.
Thank you, Justice, and good morning. And I should just say, in respect of scheduling, I don't expect to be more than an hour this morning, and I advised my friends next in line, the Caring Society and the Assembly of First Nations, of that last night. So I expect we may get a little farther today, such that on my count, we may be able to be finished by around lunchtime tomorrow.
Okay, thank you.
And Justice Favell, if I may interrupt, I'm prepared to proceed today. I think I'm next in line, and I'm prepared to go if that's necessary, particularly in the interests of concluding early, if that's preferable for everyone.
Thank you, Ms. Wente. All right, we can maybe by lunchtime we'll figure out where we're at, and we'll definitively see where we're at, or at least maybe in during the afternoon break or something like that. So thank you, Ms. Wente, for that. Mr. Frater, I'll turn it back to you.
Yes, thank you, Justice. As you've noted, this judicial review involves another decision by the CHRT that we are calling the First Nations Child Decision. You'll find it at tab 3 of volume 2 of our condensed book. That decision has implications for compensation in that it enlarges the Jordan's principal class, but its primary effect is to enlarge the class of children eligible to benefit from the supports and services under Jordan's principle. As with the compensation decision, we say that this decision is unreasonable because neither the outcome nor the reasoning process that took us to that outcome is reasonable. We're pursuing 2 points in this judicial review that echo themes we advanced in the compensation decision judicial review, but which are equally critical here. First, there must be meaningful boundaries to the scope of this complaint. Second, and closely tied to the first, is that there are boundaries to the tribunal's authority. Why do we say this outcome is unreasonable? The decision leads to compensation for individuals who were never contemplated by this complaint. As I pointed out to you in the previous application, the complainant's particulars specifically challenged discrimination experienced by First Nations children on reserve, and the evidence led, understandably, was limited to that. Second, the decision provides access to Jordan's principle for those who were never shown to have suffered discrimination. Pursuant to the Canadian Human Rights Act, the tribunal is in the business of identifying and rectifying discrimination. It has no jurisdiction to order a policy improvement unconnected to the complaint as framed and pursued by the complainants. Why was the reasoning process unreasonable? In our submission, reasonable decisions are based on solid evidentiary records. Like the compensation decision, this decision is one where we say there was simply no evidence capable of supporting the decision made. Second, the tribunal asked itself the wrong question. The proper question to be asked was whether Canada's definition of First Nations child, for the purposes of Jordan's principle, was discriminatory. Had the tribunal asked itself this question, they would have been bound to find that it was far from discriminatory. I want to focus, Justice, on the way the decision was arrived at, as Vavilov suggests. And I'm not going to take you back through the passages of Vavilov at any length, because we've already done that. So the way we're arguing these two judicial reviews lead to certain economies in our submission. And I'm going to try and take advantage of that this morning. However, you do need some context for understanding this decision. But after 3 full days of argument on the previous application, you've heard much of it. I took you through what we are calling the evolution of Jordan's principle, tracing its development from a simply worded parliamentary resolution through the merits decision and subsequent panel decisions through to the critical decisions in 2017 that set out the panel's full expression of Jordan's principle. That journey is detailed at tab 16 of volume 1, if you need to refresh your memory at all. I don't need to take you back through the complaint and the particulars again. We've spent a fair bit of time on that already, but I would encourage you to read them again, not for what you will find written there, but for what you will not find written there. You will not find any reference to the discrimination faced by non-status children living off reserve who nevertheless identify as a member of a particular First Nation, or about the challenges faced in obtaining services by a child who has one parent with status. Not a word. The tribunal held in 2017 CHRT 14 that Jordan's principle is a child-first principle that applies equally to all First Nations children, whether resident on or off reserve. Now, that may seem straightforward enough, but only if there is a shared understanding of the term First Nations child. You will note that the tribunal applied its definition off reserve, though the complaint was about discrimination experienced by First Nations children on reserve. You'll recall on Monday, I read to you paragraph 17 of the particulars of the complainant that said exactly that. Now, the litigation that leads to this decision was a non-compliance motion brought by the Caring Society. And you'll find the essence of that allegation in the excerpts from the motion we have produced at tab 22 of volume 1 of our condensed book. And I'd like to take you there briefly, just so you understand how we got to this decision.
I am there. Thank you.
So if you go about halfway down the page, Justice, there's a paragraph that starts, "This motion is for further relief."
Okay.
To ensure that this tribunal's orders of January 26th and so on are effective, specifically regarding the definition of First Nations child in those orders. This motion is made under Rule 3, so on and so on, and under the tribunal's continuing jurisdiction. The proposed motion will be heard orally. And take notice that this motion is for, 1, an order that, pending the adjudication of the compliance with this tribunal's orders of Canada's definition of First Nations child for the purpose of implementing Jordan's principle, and in order to ensure that the tribunal's orders are effective, Canada shall provide First Nations children living off reserve who have urgent service needs but do not have Indian Act status and are not eligible for Indian Act status with the services required to meet those urgent service needs pursuant to Jordan's principle. Again, the essence of the issue is who is that going to apply to? Because in order to apply it, you have to know who is a First Nations child. We say that questions of identity are not easy in any context, and we do not pretend that they are. But for the purpose of focusing on the nature of the issue that the tribunal had to decide, we say it would be helpful to you to provide some additional context. And for that, I want to take you to the affidavit of Dr. Valerie Gideon, who was at the time an assistant deputy minister at Indigenous Services and is now the associate deputy minister. You'll find her affidavit at tab 23. And in our submission, this is particularly important context to this application. And so I want to take you through that fairly carefully. Generally speaking,
Mr. Prater,
yes.
Mr. Prater, before we begin, or before we continue with the reference you're taking us to, use the word identity. Whereas I think that in the decision, the tribunal is referring to eligibility. So are you saying that they're interchangeable, identity versus eligibility, or can you clarify?
Well, basically, who is eligible? A First Nations child is eligible. How do we know who a First Nations child is? There has to be a definition. So that's why we're calling this the First Nations child decision, because it's entirely focused on defining First Nations child for the purposes of Jordan's principle. I accept my friend's approach too, where they say it's about eligibility. That's the effect, but it's really about defining that term, because otherwise you don't know who qualifies.
Thank you.
So one of the important things about Dr. Gideon's affidavit is it outlines the way in which the issues arose. Sorry, Justice, I'm at tab 23 of volume 1.
Okay, I'm there. What is there a paragraph that you had identified?
Yes, I'm going to refer you to particular paragraphs, but generally, let me describe it this way. The affidavit outlines the way in which the issue arose. It was subject to discussions at various collaborative tables involving First Nations and the federal government, and that Canada had sought to have discussions about that definition. But the issue was no one really had proposed a definition. Dr. Gideon describes in this affidavit how the definition relied on by the government had been expanded to reflect the fact that Bill S3, which had amended the Indian Act to respond to the successful constitutional challenge in the Deschanel case relating to sex-based discrimination provisions, had come into force in December of 2017. You'll find that at paragraph 15 of the affidavit. And I'd add that further changes came into force after this affidavit in relation to Bill S3 in August of 2019. But let's start at paragraphs 17 and 18, because in those paragraphs, Dr. Gideon describes how Indigenous Services went about expanding the definition of First Nations child. So in paragraph 17, she notes that in July of 2018, she'd written to the parties to clarify the expanded terms of eligibility. And then in paragraph 18, what she says is, in my July 2018 correspondence, I advise that non-status Indigenous children ordinarily resident on reserve are to be included in any requests under Jordan's principle. I confirmed that the expanded terms of eligibility would apply to any requests that were pending and on a go-forward basis. I clarified that First Nations child would encompass all of the following. So here are the categories that she enumerates. First, children with a status number. Second, children entitled to registration under the Indian Act, including those entitled to registration pursuant to the December 22nd, 2017 amended provisions of the Indian Act under Bill S3, and 3, non-status Indigenous children who are ordinarily resident on reserve. Now, in paragraph 20, she goes on to define what ordinarily resident on reserve means, and is defined as an Indigenous child who lives on reserve, normally lives on reserve despite child or one of the members of their household, such as siblings, parents, extended families with child, may have been required to spend some time away temporarily from the community to access services such as healthcare or education when there are no comparable services available in the community. Third, was ordinarily resident on reserve immediately prior to accessing those services. Fourth is a dependent of a family that maintains a primary residence on reserve. Fifth, returns to live on reserve with parents, guardians, caregivers, or maintainers during their year, even if they live elsewhere while attending school or to receive medical care or other services. And finally, meets student eligibility requirements in the reference province or the Yukon Territory. So what is explained there in my submission is that Indigenous Services was taking quite a liberal view of who ordinarily resides on reserve. The fact that you're off for periods of time does not mean you are ineligible. Doesn't require an individual to reside on the reserve at all times. And you see in both that paragraph and the following paragraphs of 21 and 22, further extensions of the definition. So in 21, you'll be considered ordinarily resident on reserve where the child's parent or guardian lived on reserve at the time the child was taken into care, or a child goes into the care of a guardian who lives off reserve. And in 22, there's what I would say is a liberal definition of the term reserve. Paragraph 23 records that Canada, after putting out this definition, respectfully waited for the Assembly of First Nations to respond to a request for input on that definition. Paragraph 24 notes that there were few Jordan's principle requests from non-status requesters, but when there was, working with the requesters enabled almost half of them to qualify, basically by assisting them to explore whether they fit in one of the extended categories. Now, Justice, what I say emerges from that narrative is a picture of a definition that is liberal in its terms and arrived at after respectful discussion. Next, what you have, but to note, it's all about connected to reserves. That's a common theme running through all of those paragraphs. And you'll recall, as I said at the outset, the discrimination alleged in this complaint was about children living on reserve. So what you end up with is a definition that ties the definition to the reserve, but doesn't require that to be eligible, you have to have spent 100% of your time on reserve. It's an attempt to have a sensible definition that accords with the way people live their lives. Next, what you get at yes.
Just a clarification. The use of the term in paragraph 20 of Indigenous child, and we're talking about First Nations, because I think definitions are kind of important. Explain the use there when we're talking about First Nations children.
I think to be consistent, we probably should have used the term First Nations throughout it. But we're not always consistent in our own language too, I would concede.
Okay.
What you find next in this affidavit at paragraphs 26 to 32, and I won't read all of them to you, but it is a discussion of the case of SJ, who is a child living in Toronto and who was the subject of the Caring Society's complaint, and her circumstances were described in the motion. So in Dr. Gideon's description, SJ is a child living in Toronto without status who needed to go to Edmonton for a study and asked for funding for 2 escorts. So that request was fielded by Indigenous Services, who took the request seriously, found out that the province of Ontario would not fund such a request for any resident of Ontario, not just SJ, but for any resident. So Indigenous Services once again worked with the applicant, but determined that the child or the parents were not registered or eligible to be registered, and the request was denied. The balance of the affidavit goes on to further describe the state of play on discussions on the issue and the desire to work out solutions. But it is clear in my submission that what Canada sought to do was include as many children as could reasonably fit into a liberal definition that respected the complaint that was brought in this case. But some children and their parents do not come within that definition. Nothing in that narrative reveals anything remotely discriminatory to Canada's approach. The approach used was grounded in 2 things: a substantial tie to a reserve, which I say again, on the complaint as framed by the complainants, was the locus of discrimination in this case, and the Indian Act, which, as noted at paragraph 40 of the affidavit, is relied on by the government to identify First Nations children. Now, the legal issue identified by the Caring Society was whether Canada was in non-compliance with the orders of the tribunal. So how did the tribunal deal with the issues? Let's go back to tab 22. So I took you through the notice of motion, and then if you have it, we've got a category called Tribunal's Approach to the Issues. So this is from the what we're calling the First Nations Child Decision, 2020 CHRT 20, that is contained in full at tab 3 of volume 2 of our authorities. So let's look at how the tribunal decided to approach the issues. And what the tribunal says at paragraph 114 is the question to be determined here is if Canada's current eligibility criteria under Jordan's principle remedy the discriminatory practice and are sufficiently responsive to the panel's reasons, findings, and orders. Paragraph 115, panel says, it's mentioned in the interim ruling, the panel still, and I should pause there just to note that there was an interim ruling, and then it took the panel well over a year to issue a final decision on the matter. But we did not include the interim ruling, which dealt with urgent cases under the definition. So, to go back to 115, as mentioned in the interim ruling, the panel still believes it would be unfair to make a finding of non-compliance of the tribunal's orders against Canada, given that while the tribunal did not use the Indian Act registration provisions as an eligibility criteria and did not limit Jordan's principle to children on reserve, it did not provide a definition of who is a First Nations child eligible under its Jordan's principle orders, and refers back to 2019 CHRT 7. While it is accurate to say the tribunal did not provide a definition of a First Nations child in its orders, it is also true to say that none of the parties, including Canada, sought clarification on this point until this motion. To be fair on this issue, the panel believes that it should focus on ensuring remedies are responsive to the discriminatory practice in light of the evidence before it and in the best interests of children, rather than on Canada's compliance. On this point, the panel agrees with the Anishinaabe Nation and the AFN that the best interests of child should be interpreted through an Indigenous lens. Panel considers First Nations perspectives of the best interests of their children in determining the matters in this case. Now, let me just pause there, because those last two sentences indicate a certain circularity in reasoning in my submission. The issue here is not about the best interests of children. It's about whose interests whose interests are we talking about? Who is a First Nations child? There isn't an issue about looking after best interests. It's determining who is going to get the supports and services. Paragraph 117, tribunal says, in light of the above, the panel does not make a non-compliance finding against Canada here. Rather, it will examine the responsiveness of Canada's eligibility criteria to Jordan's principle, including to Jordan's principle's objective, previously found by this panel and already mentioned above, and its responsiveness to the panel's previous orders. The panel, following its past approach, will also examine if there is a need for further orders to clarify its previous orders so as to ensure their effectiveness. Now, we're a good ways into the judgment, and the panel has just found that Canada is not in non-compliance. It's a non-compliance motion. Ordinarily, that's the end of it. If you're not in compliance and the decision maker is not willing to find that you are, the motion is unsuccessful. The tribunal did not stop there. The tribunal, in our submission, is admitting that we could not have known that they would take an expansive view on the definitional issue, such that issuing a non-compliance order would be unfair. Nevertheless, the impact is that each of these children and their parents will be able to claim the statutory maximum compensation, including the maximum amount on the basis that Canada was willful and reckless. Now, yesterday, in reply, I took you to the law on willful and reckless, which is at paragraphs 130 to 132 of our fact. I'm not going to repeat that. But in our submission, there's no reasonable argument to give compensation on the basis of willful and reckless in these circumstances to this class of people. There is certainly no wanton and heedless behavior to justify that. Now, with respect, that result alone, that part of the result cannot possibly meet the Vavilov internal rationality test. It is plainly absurd. There is circularity to the reasoning, and that is another thing that Vavilov says is unreasonable. Paragraph 104. We've been relying on the part of paragraph 104 that refers to relying on generalizations, but circular reasoning is also a problem here. The panel had to focus on the definition. So on a non-compliance motion, once it found that Canada was compliant, there was only one other question the tribunal was entitled to ask. Is Canada's definition discriminatory in the sense of, does it perpetuate the discrimination alleged in the complaint? The question to ask is not whether the Indian Act is discriminatory at large, or whether there is discrimination against off-reserve children. Inherent in the question is the question of whether there was any evidence that Canada's definition discriminated. That is not the question the tribunal asked itself. As I read their approach in paragraph 117 that I just read to you, the inquiry the panel launched into was into the responsiveness of Canada's eligibility criteria to Jordan's principle and its responsiveness to the panel's previous orders. Now, with the greatest of respect, neither of those approaches are the right question. On the first question, the responsiveness of Canada's eligibility criteria, the panel had already found Canada to be in compliance with its orders on Jordan's principle, i.e. that Canada was observing the definition in the 2017 decisions. Therefore, any problem with Canada's response would have to be as a result of a new direction and yet another step in the evolution of Jordan's principle. Again, evolving from a resolution of the House of Commons regarding jurisdictional disputes to a legal principle requiring the provision of a wide array of services to a wide group of individuals. And I pause to say, as I said on Monday, we're not seeking to roll back Jordan's principle, at least as it was conceived of in the 2017 decisions. Now, the tribunal's second articulation of the question, Canada's responsiveness to the orders, was settled in the previous paragraph by saying that Canada could not have been unresponsive to orders since the parameters of the definition had not been determined. Well, at paragraph 116, the tribunal said, the panel believes that Canada has been responsive to the tribunal's Jordan's principle orders to a great degree. So again, we say the right question is the obvious one. Was Canada's definition discriminatory? As you well know, asking the wrong question is a well-established form of unreasonableness. The recent Federal Court of Appeal decision in Ennis a case that was released by the Court of Appeal following the filing of our factum, and we've given you a part of it at tab 26B of our condensed book, is one of those cases that says asking the wrong question is a ground of judicial review. And I should just pause as well. What we've given you at tab 26, just for your information, because I didn't take you there yesterday, is what we did is do a search of the Federal Court of Appeal database to see what the Federal Court of Appeal had said about Vavilov since we filed our factum. And what we've given you at tab 26 are the three cases that we say are the most thorough treatments of Vavilov. I'm not going to rely on any of them in particular here. We just wanted you to have that to show you what might be binding on you in this case. So the problem with the tribunal's reasoning is perhaps even more fundamental. What they had to look at is, was there evidence of discrimination here? The Caring Society led evidence in relation to one individual, SJ. And as I told you, the case involved a claim for reimbursements for travel expenses that no person in the province of Ontario would be reimbursed for. The tribunal dealt with that case in its interim ruling and repeats that reasoning here. And that's of some assistance to you. So let's have a look at that. In the same tab that I was taking you to, tab 22, we have no, I'm sorry, it's actually missing. We'll have to go to volume 2. Apologize, Justice. You go to tab 3 in volume 2. We have the printout of the entire decision. Let's go to paragraph 210, because this is the reasoning of the tribunal where they found Canada's denial of the request in SJ's case to be unreasonable. So what they said, sorry, Justice, I can't see you. Oh, okay, you're back now. Sorry, I had a lovely picture of Ms. Wente there for a while. Paragraph 210, the panel found Canada's denial to be unreasonable. The outcomes of SJ's case is unreasonable. The coverage under Jordan's principle was denied because SJ's mother registered under 6.2 of the Indian Act and could not transmit status to her in light of the second generation cutoff rule. This is the main reason why SJ's travel costs were refused. The second reason is that it was not deemed urgent by Canada when in fact the situation was not assessed appropriately. Finally, no one seems to have turned their minds to the needs of the child and her best interests. There is no indication that a substantive equality analysis has been employed here. Rather, a bureaucratic approach was applied for denying coverage for a child of just over 18 months who has been waiting for this scan from birth. This type of bureaucratic approach in programs was linked to discrimination in the merits decision. Well, with respect, again, there's a bit of circularity here because the issue is Jordan's principle doesn't apply to every child in Canada. It applies to First Nations children. So the issue that has to be decided, and the only issue here, is who is a First Nations child. So we say, in relation to that reasoning, there's two distinct and important flaws. The first is that the tribunal only had jurisdiction to assess whether something that formed part of the complaint was discriminatory, and only had a complaint before it regarding people living on reserve. To decide whether there was discrimination against non-status people living off reserve, you need evidence regarding non-status people living off reserve. With respect, the facts of the SJ case, and we're acknowledging that there's some evidence, the evidence of SJ's case, but that is a very thin reed upon which to make a finding that the entire group faces discrimination and justifies an order like the one granted here. What the panel had by way of evidence is inadequate in our submission to make such a broad order. In our submission, it is a serious thing to make an order that requires First Nations to engage with Canada on figuring out who is recognized by their community, and then order Canada to fund their capacity building to be able to engage. It might be justified as a matter of policy if you are addressing a problem of discrimination against a group that had been the subject matter of a complaint, with the evidence that that would appropriately involve. But that is not what we had here. The record in this case pales in comparison to the record my friends provided regarding the inequities of funding. Now, with respect, what the tribunal was doing here was simply making policy. There's no other way to describe it. They had no complaint before them about this group of individuals, no evidence that could substantiate a claim of discrimination. Did those children experience service gaps, unreasonable delays, denials of essential services? The case brought by the complainants in this complaint focused on the underfunding of child welfare services for individuals on reserve. Now, this was the very point made by one of the complainant's expert witnesses, Dr. Nico Trocme, one of Canada's most experienced researchers in child welfare and a participant in the Wenday report. And so we're going to share, because this is not in our condensed book, we're going to share on the screen an excerpt that we refer to in our factum, but we haven't given you the whole excerpt. And I think taking you to the whole excerpt gives you an important flavor for the absence of necessary evidence in this case.
Before we go there, just want to get your take on a couple of points. In paragraph 118 and 119, 118, 119 of the decision, the tribunal, I think, reminds why they're retaining jurisdiction. And again, they're talking about the goal of or the objective of remedying discrimination, and that it would be unfair for for after many years, different levels of court, to have another complainant or another complaint, and that's in 119. So, is that you're suggesting that or actually you can clarify? I don't want to put words in your mouth.
Yeah.
The retention of jurisdiction in this case, or in these particular paragraphs, in light of what you just explained, are you saying? Yeah, what's your position on that? Is that it overstepped its bounds in that respect, or just clarify for me?
Yes, that is the our complaint here. It's about the overstepping of the jurisdiction. The complaint has to mean something, and the complaint proved discrimination against children on reserve. The complaint does not respectfully give the tribunal a roving commission to right all wrongs. what the tribunal has to do is decide who is covered by this complaint. This is a definitional issue in this hearing. It's not to determine whether there is discrimination generally. It's to against any child in Canada. It's about First Nations children and the First Nations children who were the subject of the complaint. And what we say, and this is why I'm about to take you to the complainant's evidence in this case, is the complainant's own evidence acknowledged the limits of what they could show. So if we go to Dr. Trocmay's evidence, he's under cross-examination here by the Crown's lawyer, who is Ms. McPhee. And she says, just a general question, going back to your answer to question 1, when we were talking about differences in funding formulas, you know, causing problems for First Nations children living on reserve, if the data at that stage didn't differentiate the experiences between First Nations kids living on reserve as opposed to those living off reserve, is it fair to say that the funding regime that was being put forward by the federal government was causing problems for First Nations children living on reserve? Dr. Trocmay, it's very hard to, I think one has to be very careful in trying to compare funding on and off reserve. It's not just an on-off reserve distinction, it's also a reserve versus urban Aboriginal distinction. You really are comparing apples and oranges. If we were to try and understand those differences better, it would really require a systematic and much more detailed level of analysis than we are able to do, and our focus has not been on trying to understand that difference. So in our respectful submission, their own witness, Dr. Trocmay, said that the situation on and off reserve is like apples and oranges. If you want to study it, says Dr. Trocmay, you should do it in a rigorous way because there are distinctions to be made. Now, with respect, that did not stop the tribunal from extending the scope of their order to a new group of people. Now, my friends may point out that Dr. Trocmay is not being asked about Jordan's principle in that exchange, but that makes it worse, not better for them in our submission. There is no evidence about discrimination in respect of the receipt of supports and services for Jordan's principle for non-status children living off reserve. But we do know from the complainant's expert is that there are distinctions to be drawn in the situations of children living on reserve and off, and that those distinctions merit systematic and detailed analysis. Now, that glaring evidentiary shortfall posed no obstacle for the tribunal. And we say there is no evidentiary basis for what they've done. It is unreasonable. Now, that is not to say that First Nations children living off reserve may not face discrimination. It is to say that no part of this complaint was about their circumstances. Certainly not non-status children who may or may not, in some cases, be recognized by a First Nations community. Those children receive their services from the provinces. Again, I say we are not trying to roll back Jordan's principle. The tribunal's articulation of it in 2017 has resulted in thousands of supports and services to the betterment of First Nations children. But there has to be some limit on the tribunal's control over the evolution of the principle. Jordan's principle is not the exclusive preserve of this panel. This complaint had limits, and this decision far exceeds them on any reasonable understanding of the complaint. Which leads me to the second issue. What the tribunal chose to do was to turn this case into a purely legal question. When we say it's largely a factual one, is the target group facing discrimination? The tribunal clearly does not like the Indian Act, but that does not mean that Canada is compelled to ignore it. One of the ironies of their reasoning process is that they refer to the Deschanel case, which was a successful constitutional challenge launched against the Indian Act and resulted in Bill S3. The discrimination was proven in Deschanel. The government accepted the decision and the legislation was amended. No small task to amend the Indian Act, given the need for consultation and the diversity of views. Bill S3 was an important change. It was achieved as a result of long legal battles, consultation, and extensive parliamentary scrutiny. But in our legal system, if your case is that the source of the discrimination is the statute, you must challenge the statute. The tribunal cannot simply determine unchallenged legislation to be discriminatory and disregard it. No amount of citing to international law or references to the quasi-constitutional status of the Canadian Human Rights Act allows you to simply avoid the issue that the tribunal says the law is discriminatory in its effects, and without a challenge to it pertaining to individuals who were outside the complaint. This was not an issue that could be settled by simply interpreting the law. On the tribunal's own reasoning, the law itself was the source of the discrimination it was trying to address here. And we say the tribunal, in its reasons, has simply skipped over the fact that it did not have the evidence to properly decide this issue, and it tried to make it a legal issue when it was largely a factual issue. Was there a group that was facing discrimination? So,
Mr. Frater, just a question on that point. I know that there's been references to the framework, the protocols, and the record refers to those. But is it a requirement to legally challenge things, or can groups talk about discriminatory aspects of legislation and find practical ways to work something out? Or is it always a legal challenge that has to precipitate things?
No, some issues can be determined through a large and liberal interpretation of a statute. But if you examine the reasoning here, what we're saying is the Indian Act is the source of the problem because it is discriminatory. Its narrow definition of who is an Indian is discriminatory. Now, what we're saying is they may be right about that issue, but the way to deal with it is by challenging the legislation, as was done in Deschanel. But we say their focus, they should never have got to that focus. The first issue they had to examine was, is there evidence that this group of children are First Nations children as contemplated by the complaint, and are they suffering discrimination? Whether they are or they're not, this tribunal could not have known because they didn't have a record. And it really comes down to that simple point in our submission.
Thank you.
So we are asking that this order be set aside. There is no point in our submission returning the case to the tribunal because it cannot make the order that it made on the basis of this complaint and the evidence before it. Returning it would serve no useful purpose. Now, I hasten to add, we are not saying that the extension of Jordan's principle in the way contemplated by this decision should never be considered. This application is, as I said at the outset, about trying to ensure that there are meaningful boundaries imposed by the complaint as framed by the parties. The Moore case tells you is the object of the exercise in a case like this. Is it consistent with the evidence presented? And we want this court to affirm that there are some limits to the authority of the tribunal. The complaint cannot be a moving target. That is our concern here. And in our respectful submission, this is not a difficult case. Our concerns are validated by the decision that you see before you and the absence of evidence to support it. So, subject to any questions, those are my submissions.
I would like to hear your position on, in light of the tribunal's denial, I guess, of looking at the third category of people, does that, or children, does that not indicate a knowledge of its boundaries?
Yes, it decided to we say they went over the boundaries and decided not to go even further over the boundaries. So there was some element of restraint, but it doesn't justify what they did do.
All right. One last question, just in terms of the what the order, I think it's characterized by the commission and others that what was ordered was not the actual delivery or the provision of services, but the benefit of being able to apply for services and to have requests considered on a case-by-case basis. So it's what are your thoughts on those submissions?
It comes back to that was being done. Everyone was getting consideration on a case-by-case basis. As I told you, Indigenous Services was trying to work with people who made requests to see whether it could fit within the definition. So that wasn't going to stop. The issue they had to decide was, who is a First Nations child? And with respect, they didn't have the evidence to make the decision that they did. It leads to an order which imposes obligations on First Nations, non-parties to the proceedings, and it is just an example of the tribunal's overreach in our submission. And so we simply ask you, as a reviewing judge, to say, you went a step too far here, tribunal.
Thank you. I think that's it for now. So thank you for your submissions.
Thank you, Justice.
I think just in terms of our time, Caring Society, would you like to roll into your submissions, or would you perhaps like a 5-minute break just to get ready?
No, Your Honor, I'm ready to roll. Perhaps we could go until about, I've kind of got a halfway point in my submission, which I think will come around 11:15, which might be a good point for a break. It won't make things too long before lunch.
that sounds reasonable. I'll turn it over to you, Mr. Taylor.
Thank you very much, Your Honor. So my name is David Taylor, and I'm appearing on behalf of the respondent, First Nations Child and Family Caring Society of Canada, on this application for judicial review. And I'm speaking to you this afternoon from the traditional and unceded territories of the Algonquin Nation. Before I begin, I'd like to express some sincere thanks to Elder Sakani, not just for his words opening the hearing on Monday, but for his continued attendance at the hearing throughout the week. I'd also like to pause here to note for anybody watching the hearing at home today and who may experience difficulty and need support given the subject matter we're dealing with, that the Indian Residential Schools support line can be reached at 1-865-925-4419. And if you missed that, the court has the number posted on its slide, which will go up during the recesses today. Now, as Mr. Frater outlined, this judicial review arises from two decisions that the tribunal made in 2020. And from the Caring Society's perspective, these decisions ensure that all First Nations children across the country, or at least a substantial number of them, are able to seek help to access public services to meet their needs in circumstances pursuant to Jordan's principle. These decisions resolved a dispute between the parties that flowed from non-compliance motions regarding Jordan's principle that were brought following Canada's initial efforts to implement Jordan's principle following the merits decision. Unlike the compensation judicial review you heard in the first part of the week, which was an issue on which the tribunal required further submissions from the parties following the merits hearing before making a decision, the eligibility decisions regarding Jordan's principle arose from a disagreement between the parties regarding the implementation of orders that the tribunal had already made. And this context is significant, and it's given no weight by Canada in its submissions on what had to be shown and the question that the tribunal had to answer. This was about the tribunal exercising its jurisdiction under subsection 53(2) to make effective orders to resolve the discrimination and cease it from recurring. Part of that jurisdiction involved ensuring that any orders made by the tribunal didn't lead to further discrimination. That would be contrary to the purpose of the Canadian Human Rights Act. You can't cause more discrimination by solving the discrimination that was before you. However, similarly to the compensation judicial review, the eligibility decisions are intertwined with the tribunal's conclusions in earlier decisions, which were accepted by Canada, and as such are final orders. And I just pause to note here, Mr. Frater placed a great deal of emphasis in his submissions on the distinction between on and off reserve contexts, and says that Canada's not trying to unwind or turn back the clock on Jordan's principle. Well, respectfully, the submissions this morning seek to unwind a very important order made in September 2016, which was not judicially reviewed, that Jordan's principle applies on and off reserve. I'll get that to that in more detail later in my submissions, but it's very important to emphasize that the application of Jordan's principle off reserve was something that was decided nearly 5 years ago and wasn't judicially reviewed by Canada. So it's hard to see how in this judicial review, it can be grounds for unreasonableness that the tribunal followed that conclusion or followed that point of law, that legal conclusion through to its natural result. Now, on the non-compliance motions below, the Caring Society sought orders sought these orders because of restrictions that Canada imposed on which First Nations children were eligible to be considered, and that's an important point, eligible to be considered under Jordan's principle. Canada categorically excluded First Nations children living off reserve who did not have Indian Act status. Now, despite Mr. Frater's assertions that these children would receive help in the form of service navigation and attempts to, fit round pegs through square holes, at the end of the day, the result of that case-by-case analysis, if that child needed money from the federal government pursuant to Jordan's principle, was always going to be no. And SJ's case demonstrates that, and we'll talk about that a little bit later this morning. This means that First Nations children living off reserve who did not have Indian Act status were not even allowed to be considered under Jordan's principle. These children were denied the ability to get help or to ask for the help they needed. This is the latest in a long series of attempts by the federal government to close the door on substantively equal access to public services for First Nations kids, a right that's protected under the Canadian Human Rights Act. As a human rights concept, Jordan's principle has always been about achieving substantive equality. It's vital to note that in its effort to close the door, the federal government clings to one of the chief colonial instruments that Canada has wielded to wreak havoc on First Nations cultures over the decades, and that's status under the Indian Act. Jordan's principle reflects the needs and circumstances of First Nations children. This is fundamental to its nature. Indian Act status does not. The evidence in this case spoke to the Indian Act's colonial and assimilative purpose. For instance, Dr. John Malloy, an expert on the history of Indian residential schools called by the Assembly of First Nations, testified as follows, and this is at tab 4 in the condensed book. You don't need to turn it up. So that becomes the heart of the Indian Act of 1869 and the Indian Act of 1876, and every Indian Act thereafter, that civilization becomes, in a sense, the disappearance of communities, rather than what it had been before, the civilization of communities, because now civilized people would march forward into Canadian citizenship and the old people will die off. The question before the tribunal was whether Indian Act status is a concept on which Canada may rely to categorically exclude First Nations children from Jordan's principle. In the eligibility rulings, the tribunal reasonably found that this categorical exclusion was unacceptable and confirmed two specific groups of First Nations children who were eligible for consideration and endorsed the process developed by all of the parties, including Canada, to implement its orders. Now, I have 5 parts to my argument this morning. The first is to consider the nature of the question before the tribunal, which I've touched on briefly already. The second is to go into a little bit more detail than Mr. Frater about the context for the orders in terms of the procedural history leading up to the arguments before the tribunal. The third is the actual order the tribunal made. The fourth is to speak of the reasonableness of the outcomes. And the fifth is to speak of the reasonableness of the tribunal's reasoning process. So turning to part 1, which is the nature of the question. The question before the tribunal was whether it was acceptable for Canada to categorically deny all First Nations children living off reserve and without Indian Act status the benefit of accessing Jordan's principle without considering their individual needs and circumstances. This is a threshold question. In response to the legal rule recognized in the tribunal's orders in 2017, Canada finally began considering service requests from a large number of children, First Nations children, on a case-by-case basis to determine if the service request should be approved to meet their needs. The question before the tribunal was whether First Nations children without Indian Act status living off reserve could get in the door to have their needs considered by Canada, or if Canada could refuse to fund those needs solely based on their off-reserve residency and lack of Indian Act status. The tribunal was clear that this was a narrow question. It relates only to whose cases may be considered for funding and not to the outcome of that consideration. Whether a First Nations child is entitled to have their request considered by Canada is a separate and different question from whether Canada will say yes or no to a request under Jordan's principle. Now, Mr. Frater this morning in his submission phrased the question before the tribunal as needing to determine whether non-status children living off reserve experienced service gaps, unreasonable delays, and denials of essential services. Now that, with respect, that is the answer to the second question. That's the answer to the question that the focal point has to answer in determining whether funding is going to be provided for an individual child's request. The first question is whether the file even gets on the focal point's desk for consideration of funding from something called the Service Access Resolution Fund, which I'll get to in a moment. And so again, this ultimate question, which is whether the First Nations child in question receives the requested service, remains to be considered at the second step in the full context of the First Nations child's needs and circumstances in keeping with the principles of substantive equality. And it's at this stage that those differences between the on and off reserve context would come into effect, and not at the preliminary step of Indian Act status or where the child lives, in terms of whether their file even gets through the door or gets past the screening stage of is there some other government that can help, which is frankly reminiscent of how Jordan's principle worked before these orders. Again, all that was being considered here was whether these kids can ask for help. Now, turning to part 2, which is the context for the First Nations child decisions. So any reading of the tribunal's decisions on eligibility has to be informed by the way that this matter came before the tribunal, which flowed from Canada's continued discrimination after the merits decision. So this discrimination continued after the January 2016 decision, despite the ministers involved having embraced the decision publicly. And the reference to their statement is at tab 349 of the Joint Electronic Record. Now, given that the government was saying one thing and doing another, the parties needed to seek further and more specific orders from the tribunal in order to bring Canada into compliance. Regarding reading the First Nations, the eligibility decision in light of the history is consistent with the Supreme Court's emphasis in Vavilov, paragraph 94, that the reviewing court must also read the decision maker's reasons in light of the history and context of the proceedings in which they were rendered. The merits decision and the non-compliance orders related to Jordan's principle, which also have the status of orders of this court given their registration under Section 57 of the Act, are a vital part of the legal context underlying the First Nations child decision. And the sequence of orders in my submission shows the nature of the discrimination in this case. Mr. Frater spent a lot of time talking about discrimination against First Nations kids. Being on reserve, being part of the complaint. And certainly the Child and Family Services program applies on reserve, and that's why the locus of the reserve was a significant portion of that branch of the complaint. The complaint with respect to Jordan's principle was about Jordan's principle writ large. And if you look at the statement of particulars of the Caring Society, it's defined quite broadly in the statements of particulars. And the same is done with respect in Canada's particulars. And when the tribunal talks in its reasons about the complaint being the complaint form, the particulars, and also the evidence in the case, to that I would also add the evidence that flowed through Canada's implementation of the order, and that's particularly true when we're in the context of retained jurisdiction and considering whether past orders made were effective. Now, in its most essential form, and this is tying back to my point of just a minute ago, the nature of the discrimination that was identified in the merits decision was Canada's Kafkaesque effort to comply with Jordan's principle by defining it so narrowly that no child ever qualified. So the narrow definition of Jordan's principle was the nature of the discrimination. As such, consideration of continued efforts to narrow Jordan's principle by unilateral selection of criteria like the Indian Act, which is not mandated by any statute, but is an administrative and executive decision made by Canada, are certainly proper field and fair game for the tribunal's consideration when evaluating the effectiveness of its orders. In 2016, this was a massive exclusion of First Nations children from consideration. Canada's narrow approach led to there being no cases that met this very narrow definition. Children had to be just like Jordan to qualify. They had to have multiple disabilities and a conflict between federal and provincial governments. Anyone who wasn't just like Jordan didn't pass the bar. In response, the tribunal's order regarding Jordan's principle in the merits decision was as simple as it was powerful. At paragraph 481, the tribunal ordered as follows. ANSTI is also ordered to cease applying its narrow definition of Jordan's principle and to take measures to immediately implement the full meaning and scope of Jordan's principle. The order was very simple: stop discriminating and fix it. In January 2016, Canada had a very wide range of possibilities to implement this order. Now my friend has spoken a lot about the evolution of Jordan's principle, and at one point accused the tribunal of being a roving, I believe he said a roving commission. The tribunal was not doing anything of the sort. The tribunal appropriately gave the federal government the widest latitude possible to resolve the discrimination identified. If there's any evolution through further orders, that's as a result of Canada's failure to come into compliance and the need for further and more specific orders to address the discrimination. So what happened next? The tribunal had further questions regarding the remedial process, leading to further submissions from the parties on immediate relief in February and March of 2016. These led to the April 2016 non-compliance order, in which the tribunal found that Canada had not acted rapidly enough to implement the order made in the merits decision. In particular, Canada's plan to take until the spring of 2017 to develop options for Jordan's principal relief was not sufficient. In the tribunal's words at paragraph 32 of the April 2016 order, the order is to immediately implement, not immediately start discussions to review the definition in the long term. Canada was ordered to apply the definition set out in House of Commons Motion 296, which I'll note makes no reference to Indian Act status, to the effect that Jordan's principle would apply to all First Nations children, not only those with multiple disabilities, and to all disputes, including those with the federal government. Following the April order, Canada was again given very wide latitude in terms of how to implement the April 2016 order. While clear guidance was given on the definition to be applied, it was left to Canada to develop the process to follow. Canada had a wide ability and an ample opportunity to fix the problems on its own. It was simply asked to implement this definition and to tell the tribunal how it had done so. Further compliance reports followed, as did further submissions. Now, in July of 2016, Canada announced a new approach to Jordan's principle, which it dubbed the Child First Initiative. As detailed in the September 2016 decision from the tribunal at paragraph 110, this involved allocating $382 million over 3 years. However, as the September 2016 decision also makes clear, there were important questions regarding the continued restrictions that Canada was imposing on its definition of Jordan's principle and the actual process the government was following to deal with Jordan's principle requests. For example, the tribunal wanted to know how urgent cases would be addressed, what accountability and transparency measures would be included in the process to ensure compliance with the tribunal's orders. One thing, however, was clear based on the information provided to the September 2016 order, and that was that the federal government was requiring First Nations children to be ordinarily resident on reserve in order to have their cases considered under Jordan's principle. Now, Canada tried to explain this in its July 2016 submission, which happened to come the day after the Child First Initiative was announced. It said that it had understood the tribunal's January 2016 decision only to apply on reserve. I'd note that's very similar to the argument you're hearing from Mr. Frater today. The tribunal was very clear that not only was this not an appropriate restriction to Jordan's principle, but that the imposition of such a restriction failed to take the perspective required under Jordan's principle. And so paragraph 118 of that decision, again, a decision that was not judicially reviewed, says that this type of narrow analysis is to be discouraged moving forward, as it can lead to discrimination as found in the decision. Rather, consistent with the motion unanimously adopted by the House of Commons, the panel orders INAC to immediately apply Jordan's principle to all First Nations children, not only to those residing on reserve. Lest I sound like a broken record, I'll repeat again, Canada did not judicially review this order. As a result of uncertainties, though, regarding Canada's process for dealing with Jordan's principle cases, the tribunal in its September 2016 order directed Canada to provide some more information in the form of a compliance report due in October 2016, which was to be followed by a case conference in November, at which the further information would be discussed. For reasons that need not be gone into here, the 2016 case conference adjourned without resolution, and the result was that the motions for immediate relief, one of which was the one resulting in the 2017 orders, were brought. So moving to 2017. As part of the immediate relief motion on Jordan's principle, Canada filed an affidavit of a senior public servant within the team responsible for implementing the tribunal's orders, Robin Buckland. Ms. Buckland was cross-examined in February 2017, and Canada provided a number of answers to requests for information arising from that cross-examination in February and March. And that information is all in the joint electronic record. You'll find that at tabs 183 to 186. And I should say that the sequence I've just gone through is also all contained in the joint electronic record. It's fairly complete as far as the record before the tribunal goes. So the evidence from Ms. Buckland's affidavit, cross-examination, and the request for information revealed that the $382 million three-year funding envelope had three components. The first was a $327 million fund titled the Service Access Resolution Fund, which existed to provide funding for requests for services that were approved by the federal government. And the remaining funding was divided between something called Enhanced Service Coordination, which was community funding to help better identify service needs, and then funding internal to what were then Health Canada and Indigenous Northern Affairs to support implementation. This was before the merger of those two departments later that year. Now, just to explain an important principle about focal points here, the Service Access Resolution Fund requests are determined by individual public servants known as focal points. They receive requests relating to individual First Nations children or groups of First Nations children with service needs. If the focal point approves the service request, it's funded from the Service Access Resolution Fund. So when Mr. Frater talks about the various steps that the government can try and take to connect non-status children with services, those are all things that are before and outside of the Service Access Resolution Fund, which is the ultimate source of funding for Jordan's Principle in terms of providing the service to meet the First Nations child's needs and circumstances. However, as the tribunal went on to find in its May 2017 order, the kinds of service requests that focal points would adjudicate in this first iteration were subject to several important limitations or several important restrictions. The restrictions are summarized in a comparative table at paragraph 57 of the May 2017 decision. And that's a before and after in terms of before the 2016 order and after. The first restriction in the table on reserve residency was addressed in the tribunal's September 2016 order, but the table revealed two further restrictions. First was a consideration under Jordan's Principle being limited to children with disabilities or short-term conditions affecting the activities of daily living. Now, given that the decision itself isn't under review and that Canada is indicating that it's not bringing these proceedings to question its legal obligations under Jordan's Principle, I'll simply note the tribunal found this restriction was not compliant with its earlier orders and that Jordan's Principle required all types of service needs to be considered and not just those related to disabilities and short-term conditions. Second, Jordan's Principle was said to apply to normative standard requests. That is to say, the Service Access Resolution Fund would provide for the same services provided to non-First Nations children by provincial service providers, with substantive equality requests going beyond the normative standard to meet a First Nations child's needs and circumstances being considered on only an exceptional basis. The tribunal found that the treatment of substantive equality requests exceptional was not in keeping with its orders. I just pause to note here that the Canada's implementation of Jordan's Principle prior to 2017, even in its more limited form, shows that it itself acknowledged before it was ordered to do so by the tribunal that substantive equality had a role to play in Jordan's Principle, even though it qualified that as only an exceptional role to play. So again, this is contrary to the suggestion from Canada that there's some evolution or that 2017 is some watershed moment. Obviously, it's the moment when the obligations become the most clear, and it's the moment when Canada begins complying more substantively with its obligations. But substantive equality is a thread that runs throughout the decisions with respect to Jordan's Principle. Now, following the May 2017 order, and this is what really leads us to the eligibility order that's under review here, is this question of who is a First Nations child, or rather who has Canada decided is a First Nations child? How is it interpreting the phrase all First Nations children in the tribunal's decision? Now, this actually came up before the 2017 order was made, because in cross-examining Ms. Buckland, the Caring Society specifically asked whether Indian Act status was being used to limit access to funding from the Service Access Resolution Fund. We were told that it wasn't. We were told that it was just a point of information, and that's at tab 2 of the condensed book, that exchange. The answer would end up changing in the reporting process that followed the 2017 order. Tab 3, you have an excerpt from the cross-examination of Sonny Perron, who is the Assistant Deputy Minister with ISC, Indigenous Services Canada, and was cross-examined in May 2018 on his compliance affidavits filed following the 2017 order. In that cross-examination, he confirmed that not only was Indian Act status an eligibility criterion for accessing the Service Access Resolution Fund, but that it had been all along. But by this time, the parties were no longer limited to tribunal motions to address concerns regarding Canada's non-compliance. After the 2018 order regarding actuals funding, the parties signed a consultation protocol following the tribunal's order for that protocol to exist. And the Consultation Committee on Child Welfare was formed to provide parties a forum for discussion for compliance concerns. And my friend took you to some of those discussions in Dr. Gideon's affidavit earlier today. The discussions continued for some months, with the result being the expansion to non-status children living on reserve in July 2018. But despite the fact that it had become very clear at this point that Canada was using Indian Act status to limit Jordan's Principle eligibility, Canada's website regarding Jordan's Principle continued to publicly state that Jordan's Principle was available to all First Nations children. And the evidence of that was before the tribunal is at tab 7 of our condensed book. With discussions at an impasse, the Caring Society raised the matter with the tribunal in late 2018, as provided for in the consultation protocol, which contemplated areas where the parties couldn't reach agreement being taken to the tribunal for guidance. And that's what led to the decision. Now, but just before I ask for a break, and just to conclude this part of my argument, I'd like to just go back to SJ's case, which was discussed by my friend this morning. And I just want to give a little bit more procedural detail. I've already given a lot, but just to clarify around her case. And so certainly the Caring Society brought its motion for urgent relief in December of 2018. There was actually a hearing on that motion in January of 2019, and the tribunal ruled in February of 2019. That was then followed by a hearing in March, a full hearing on the issue of the definition of a First Nations child for the purposes of Jordan's Principle, in which the 3 categories that you had noted earlier today and that are in the ruling were all addressed. The first hearing was limited to this question of urgent circumstances. So this was a hearing that demonstrated the urgency of resolving this question for at least some First Nations children without Indian Act status. And the case highlights that even after Jordan River Anderson's family and community's courageous efforts to bring forward Jordan's Principle, even after the House of Commons' unanimous endorsement of Jordan's Principle and the tribunal's historic ruling and the great strides made in implementing Jordan's Principle, there still is a tendency in the federal system to discriminate against First Nations kids. And that's not part of some dark chapter of our history. That's still happening today. SJ was 18 months old with a life-threatening pancreatic condition. My friend told you that she wanted to participate in a study. That was the version of the evidence they advanced before the tribunal at the hearing in January of 2019, and it was the version of events rejected by the tribunal after reviewing all of the evidence before them on that motion. Her mom had Section 6.2 Indian Act status. Her dad had no status. And so because of the way the Indian Act works, SJ didn't have status either. The procedure she needed was a diagnostic scan to inform life-saving surgery. It's only available in a handful of places in the world. Luckily for SJ, one of these places is the Stollery Children's Hospital in Edmonton, but her family needed some help to get there. The evidence showed that SJ's family was being assisted by a service navigator working for the Chiefs of Ontario. That's that second part of the Jordan's Principle implementation funding to get the needs from the community to bring them forward. But when the navigator raised SJ's case with ISC, Indigenous Services Canada, she was told no, because SJ didn't have Indian Act status, the request couldn't be considered. The request for funding couldn't be considered. There was some navigation, but the funding was a no. It didn't matter the scan was already scheduled. It didn't matter that SJ was only 18 months old, and it didn't matter that this scan would inform surgery that could help save her life. The evidence before the tribunal was clear. If SJ had had Indian Act status, her travel to Edmonton would have been funded. Because her mother was unable to pass Indian Act status to her, she received no support from the federal government for this travel. COO's service navigator then reached out to the Caring Society, which paid for SJ's travel to Edmonton and brought the motion for urgent relief to the tribunal. Canada resisted that motion, and again, as I noted earlier, attempted to divert attention away from the clear nature of the exclusion by alleging in an argument rejected by the tribunal that SJ was just seeking to participate in a research study. The tribunal rejected Canada's theory on the strength of the evidence before it, which included documentation from SJ's doctors. And then the tribunal ruled, pending full adjudication of the question, that Canada had to consider requests related to life-threatening or urgent situations from First Nations children without Indian Act status who were recognized by their nations for the purpose of Jordan's Principle. So just to sum up part 2, which is really the end of the first half of my submission to you this morning, the Caring Society submits that the context underlying this decision shows that the context underlying this decision, the eligibility decisions, shows that they are not a further expansion of the complaint. Rather, they're a response required due to Canada's continuing restrictions imposed on Jordan's Principle scope, which have only served to perpetuate discrimination against some First Nations children. First, in the merits decision, the tribunal had to address Canada's exclusion of all First Nations children without multiple disabilities, or without a disability, or who lived with only one disability, or who had multiple disabilities involving only one level of government. Then in the September 2016 decision, the tribunal addressed Canada's exclusion of all First Nations children living off reserve. And with the greatest of respect to my friend, that question is not before you today because that decision is final. Then in the May 2017 decision, the tribunal addressed Canada's exclusion of all First Nations children without disabilities or critical short-term conditions and treated substantive quality as the rule and not the exception. Now in the eligibility decisions, the tribunal addresses Canada's exclusion of two specific groups of First Nations children without Indian Act status living off reserve. And just a final note before I ask for the break, and that's just again with regard to the particulars. And so the Caring Society's particulars are at tab 10 of the condensed book, and paragraph 21(2)(a) of those specifies that Jordan's principle applies to federal government programs affecting children. So there's no limitation in that statement in the particulars to programs on reserve. And the AGC's particulars, which aren't in our condensed book, or at least this portion of them isn't, but they're at tab 9 of the joint electronic record, address Jordan's principle at paragraph 42 to 44. And 42 says that Jordan's principle is a child-first approach, which engages various health and social services and not solely child and family services. And then it goes on to provide the detail of Canada's own narrow interpretation of its implementation obligations, but again, doesn't speak of confining the principle itself to the reserve context or to kids with Indian Act status. So there's, again, just to note that in addition to this being a context of evaluating the effectiveness of the tribunal orders in the context of retained jurisdiction, which doesn't require the level of the test that my friend laid out this morning, there is also a clear indication that this is part of the claim and has been since the start. So if it's a convenient time for you, Your Honor, maybe we could take a short break at this point.
After you answer a question, we can have a break. So you heard earlier from Mr. Prater that one of the ways that this could be addressed is by challenging the Indian Act, and as opposed to the process employed by the tribunal through its remedial processes that it says. So what's your position on his submissions in that regard?
So my position on that submission is that the Indian Act is not the source of the problem in this case. The source of the problem is Canada's decision to rely on that as the metric of who it has to listen to or whose cases it has to consider under Jordan's principle. And so certainly a challenge under the Charter to Section 6 of the Indian Act is an avenue that could be open to a claimant. But much like the submission with respect to class actions on the compensation matter, human rights complainants, whether victims themselves or acting to redress discrimination against other victims, they have a wide latitude in terms of which vehicle to use, particularly where the tribunal has already made orders with respect to the discrimination in issue. And so the constitutionality or unconstitutionality of the Indian Act aside, there's no mandatory nature of that statute with respect to who gets access to the Service Access Resolution Fund. That is a decision that is solely within Canada's purview in terms of Canada's purview subject to its obligations under the Human Rights Act in implementing the tribunal's orders. And that's obvious because there are already non-status children who are eligible to access that funding, and they're the ones that are living on reserve. And reserve boundaries, they are what they are, and they have their sources, even on the liberal definition cited by my friend. But they're not Section 6 Indian Act status, and they don't pass or not pass to children, siblings, and cousins based on the particular pattern of their family tree. It's just a completely different aspect. And so the fact that there is another avenue out there that could have been used doesn't preclude the Caring Society or any of the other complainants or interested parties from further critiquing another narrowing of Jordan's principle. And I heard my friend's submission this morning that there are all kinds of other, well, we can read definitions liberally, we can try and be creative and find other measures. But the fact that there are some little windows and openings in a door that's closed to First Nations kids, in SJ's case, it shows there are still children who are going to have that door closed to them. And SJ isn't some child who's in the mainstream course of Canadian society. She's got a mom with 6'2" Indian Act status. The evidence showed her grandma was a First Nations person as well. The Chiefs of Ontario were involved in her case, attempting to help her find services. There's no one that's questioned SJ being a First Nations child. The only thing that's questioned is the legal operation of the Indian Act not providing her status. And so for kids like that, the question was, is that a means of making the implementation of the tribunal's orders effective or not? The Caring Society said it wasn't. The tribunal said it wasn't. And we say here that they were reasonable in so concluding.
Thank you, Mr. Taylor. Now's a good time for your break, our break. So we'll reconvene. Is 5 minutes appropriate for you?
Maybe 10, Your Honor, if you wouldn't mind. Just a chance to stretch my legs.
So let's reconvene at 11:25.
Thank you very much.
Okay, thank you.
Perfect. This is well noted. The court is now in recess. Thank you.
Recording stopped.
Would you like to do a round of council just to confirm, sir?
That's a good idea, so we don't leave anybody behind.
Perfect. Can council please advise if you are back from break, please? Thank you.
Caring
Yes.
Society here.
Canada's here.
The Assembly First Nation is here.
Apologies, everyone. Just getting my camera back on, but Human Rights Commission is here. Thank you.
Chiefs of Ontario is here. Thank you.
And Nan is present.
Amnesty is here as well.
Perfect. That confirms everyone for what I am seeing. Yes. Okay. I will start the recording.
Recording in progress.
The court is now resumed.
I can't remember. I was looking at my notes as opposed to the screen. Did Mr. Loken respond?
Oh, that is correct, sir. I don't believe Mr. Loken did confirm. Oh, I believe he's here. You're muted, so you can hear me well.
Yes, my apologies.
Thank you. I confirm everyone is here now. Justice Fable.
Perfect. Mr. Taylor, you can continue.
Thank you very much, Your Honor. Now, as often happens, a thought came to me over the break, and there's just one more point I wanted to make about SJ's case and my friend's characterization of the evidence a little earlier today. And he characterized the request for funding as being for escorts to bring her to this, what he called a study, and what was actually a scan needed to inform life-saving surgery. And just to really clarify for the court, the escorts were SJ's parents. So this was a question about whether an 18-month-old could have her parents travel with her to Edmonton and have that support for a scan to inform life-saving surgery. Now, moving on to part 3 of my submission this morning, which is to consider the order that was actually made, or the orders that were actually made. So given this is a judicial review, it's important to consider what the tribunal actually did in the eligibility decisions, and it's actually quite limited. Again, despite my friend's suggestion of a roving commission, although I hope I'm quoting him correctly. I got the word roving. I'm not sure what the noun was that followed the adjective. The decision doesn't include all First Nations children off reserve without Indian Act status. It's directed at 2 specific groups of First Nations children based on the tribunal's evaluation of both the law and the evidence in this case. The Caring Society's request was actually broader than the 2 groups at issue, as the Caring Society said that First Nations children who had lost their connection to their community due to colonial practices by Canada, like the residential schools system and the 60s scoop, should be included as well. And I'd note that the discrimination in the Child and Family Services system stretches back to the 1990s, and as a parent myself of not quite that vintage, but not far away from it, there are kids in my generation as well who would be needing the benefit of Jordan's principle, who may have lost their connection to their communities. But the tribunal disagreed with the Caring Society's request to include this and did not grant an order on that basis. And the reason it did so is significant. It found that it didn't have sufficient evidence before it. So Canada's characterization of a tribunal that is unbound from the norms of the legal system, it just simply doesn't play out in this decision. It considered the law, it considered the evidence, and it made orders accordingly, or in the case of the 3rd group of children, didn't. That's what tribunals do. And for your reference, that conclusion is set out in paragraphs 274 to 320 and should be borne in mind when considering Canada's claims of overreach. That was a short part, so we'll move to part 4, which is the reasonableness of the outcome. So the outcome of the order, again, addresses only a threshold matter. No part of the order requires Canada to do anything other than receive and consider requests from 2 groups of First Nations children without Indian Act status living off reserve. All that Canada is asked to do is listen to requests for help from kids like SJ. Canada's position that this outcome is unreasonable has nothing to do with meeting children's needs. and is a stark reminder that even in the face of historic orders from the tribunal telling Canada to change its old mindset, it remains focused on colonial definitions and narrow approaches. No part of the tribunal's order requires First Nations to do anything at all. The order, as completed by the later process order in 2020 CHRT 36, simply provides a procedural avenue for First Nations to confirm their recognition of a First Nations child without Indian Act status living off reserve. By no means are First Nations required to do so. Assertions that further discussions are required with First Nation are a further example of bafflegab from Canada. A workable avenue for confirming recognition is already available and provides a means to implement the orders. Indeed, Canada's assertion that further discussions are required echoes its initial response to the merits decision to talk about helping kids rather than actually helping kids. The way in which this matter came before the tribunal also undermines any suggestion that discussion with First Nations plays any part in Canada's approach to this question. Canada provided sworn evidence in 2017 in the proceeding below that a lack of Indian Act status was no bar to receiving Jordan's principle. It was just a point of information. It took 15 months for that wrong statement to be corrected on the record, and even then that was only when a more senior official was subject to cross-examination on an affidavit. There was no proactive disclosure from Canada. Even with the record corrected in this proceeding, Canada's website on Jordan's principle continues to be completely silent regarding Indian Act status being a requirement to access Jordan's principle. These are not the actions of a party looking to engage in transparent dialogue with First Nations in order to ascertain their views of a proper definition. They are the actions of a government hiding the ball. With that said, I have 3 specific points to make on the reasonableness of the outcome. First, the outcome was consistent with other remedial principles involving First Nations people. The outcome is consistent, for instance, with Supreme Court of Canada decisions addressing other remedial principles, for instance, in the carceral context. Before the tribunal, and again in its factum before this court, the Caring Society points to the Supreme Court of Canada's decisions over the last 20 years addressing remedial legal rules as they apply to Indigenous persons and that have no regard to Indian Act status. And these are found in the Gludu and IPLE cases, which address the sentencing provisions in the Criminal Code, and the Ewart decision, which addresses Correctional Services Canada's implementation of its statutory mandate. Gludu and IPLE address sentencing of Indigenous offenders and principles designed to ameliorate their overrepresentation in the criminal justice system. Ewart involves the Correctional Service of Canada's reliance on psychological and actuarial risk assessment tools that failed to consider Indigenous offenders' needs and circumstances, including needs and circumstances that differed from those of the non-Indigenous offender population. In all 3 of these decisions, we see echoes of the purpose served by Jordan's principle: to address historic disadvantage faced by First Nations people, in this case, First Nations children, by meeting their needs and circumstances. None of the principles considered in Gludu, IPLE, or Ewart were bound up in the offender's Indian Act status. It is entirely reasonable as an outcome for the tribunal to refuse to allow Canada to close the door to Jordan's principle based on the Indian Act as well. Second, the outcome of rejecting a categorical exclusion of children with one parent with status under Section 6.2 of the Indian Act is entirely consistent with the heavy criticism that the Byzantine rules surrounding Indian Act status have faced in the superior courts. The effect of Section 6.2 is to create a distinction between First Nations parents. There are those who can pass Indian Act status to their children on their own, i.e. who have status under Section 6.1, and those who can only do so if their child's other parent also has Indian Act status, and that's those with status under Section 6.2. This is the second generation cutoff, and its effect has spawned a multitude of constitutional challenges seeking to delay the impact of Section 6.2's second generation cutoff by at least a generation. These decisions have involved harsh criticisms of Indian Act status, many of which are addressed in our factum. To highlight but one example, we have included Justice Barrin's decision in Hele versus Canada, which is at tab 21 of our condensed book, in which Justice Barrin noted the problematic history of the Indian Act. the failure of the 1985 amendments to resolve those inequalities, and the continuing effort in which courts are engaged to iron out the creases, as he termed it. Given the lengthy and numerous equality-based challenges to which the Indian Act has been subject, an outcome in which Canada was not permitted to rely on a much criticized instrument of colonial policy to categorically restrict the consideration of needs under an ameliorative principle can't be an unreasonable one. And again, I circle back to my answer to your question before the break, Your Honor. It's a decision that Canada is making on its own. There is nowhere that it is legislatively required to consider Indian Act status in implementing Jordan's principle. And I'd also just pause to note, in terms of the evidence before the tribunal, there's tab 321 to the Commission's book of documents, which I believe is in volume 11 or volume 12. And that's a policy document from 2005, internal to government, and was one of the documents withheld from the disclosure disclosed following the Caring Society's access to information request. And pages 3 and 4 of that document note the government's own understanding that Indian Act status is a suspect ground possible to challenge in the legal system. My third point on reasonableness of the outcome has to do with Canada's own commitment to implement the tribunal's orders that are under review. And I have to say, as a responding party, it's a very odd circumstance to be in a situation where one of the orders under review will be implemented regardless of the outcome of the proceeding. So this is with respect to the tribunal's order that refused to allow Canada to rely on the categorical exclusion where the child was recognized by their nation. And in this case, tab 357 of the Joint Electronic Record contains a statement made by the Minister of Indigenous Services on the day that the notice of application underlying this judicial review was filed. And that statement says, the Honourable Mark Miller, Minister of Indigenous Services, announced today that Canada will expand eligibility under Jordan's principle to children who are recognized as members by their nation, regardless of where they live in Canada, on an ongoing basis. This is a clear indication that the outcome is reasonable. If it is something that the government will implement, regardless of what happens before this court, it cannot be otherwise. It also indicates that this portion of Canada's judicial review is an abuse of process. In QP versus Toronto, the Supreme Court of Canada made it clear that the doctrine of abuse of process can be used in varied contexts to prevent the misuse of the court's procedure. This is a clear example in which that doctrine can be used. This aspect of the judicial review can be dismissed on this basis alone. Canada seeks to evade a legal order to which it does not object. This also raises serious questions with respect to the honor of the Crown, given Canada's decision to litigate over legal obligations to First Nations children to which it does not object. There are also particular concerns regarding Canada's attempt to evade legal obligations following from the tribunal's orders, given the history of this case, including the facts leading up to this very judicial review in SJ's case, which demonstrates that Canada cannot be left to its own devices when it comes to ending discrimination against First Nations children. Now, in terms of the fifth and final portion of my argument, which is the reasonableness of the reasoning process. And here again, Vavilov requires us to start with the decision, to look at the reasons the tribunal considered and the thread that ran through them. It doesn't require you as the reviewing court to do what Mr. Frater encourages you to do, which is to start from Canada's wish list in Dr. Gideon's affidavit. This is a matter that's internal to the tribunal's reasons, which are before the court. So the question is, how did the tribunal address the threshold question? Turning to the reasons, the tribunal provided the clear and cogent chain of reasoning required by Vavilov over the course of its 103-page decision. It's important to recognize we're not dealing with a terse letter decision. This is a carefully crafted justification of the tribunal's orders. It is hard to see what more Vavilov could require. Now, grounding first the review of the reasons in its context, which is just what the tribunal did in looking at the context it faced. It recognized the narrow nature of the question it was being asked. It recognized that it was not being asked to decide parameters for First Nations identity at large. It was being asked whether a lack of Indian Act status combined with off-reserve residency could absolve Canada of the need to consider a First Nations child's service needs under Jordan's principle. The tribunal also recognized the diverse perspectives on this issue and considered the several and varied authorities that constrained the answer to this question. The tribunal specifically solicited submissions from the parties to address First Nations' right to self-determination, international law, Canada's new legislation regarding child and family services for First Nations, Inuit, and Métis children, the Indian Act, and Section 35 of the Constitution Act, 1982. In addition to recognizing the limited nature of the question and the range of perspectives to be considered, the tribunal also bore in mind the way in which the question came before it and the stage of the proceedings. At paragraphs 115 and 117, the panel specifically held that it was not going to make a non-compliance finding against Canada. It noted that it didn't define a First Nations child for the purposes of Jordan's principle in its prior order, and that it was only at this stage that the parties sought the clarification. Now, my friend made some ado over this idea of a refusal to find non-compliance, but that also ignores the context of the tribunal's prior orders in this complaint. In the 2017 decision in particular, the tribunal set out that its function in retaining jurisdiction was not to adjudicate compliance or non-compliance of orders that were brought to it. And regardless of the fact that that is how the parties characterized it, what you need to focus on as the reviewing court, Your Honor, is how the tribunal characterized it. It said that it would evaluate whether its orders were effective and whether further orders were required to ensure that the discrimination ceased and didn't recur. It said that it may make certain findings in the course of performing that function as to whether the orders had been complied with or not, but declarations of non-compliance was not what it was in the business of doing. And so the recognition at paragraph 115 that this is falling in the same context once again is not an indication. 115 and 117 is not an indication that the tribunal had concluded its job was over. It was simply the tribunal resituating itself in the procedural context facing the parties. And again, this focus is described not just in the May 2017 decision, lest my friend tell me I'm going outside the decision, but in paragraph 115, where the tribunal says it should focus on ensuring remedies are responsive to the discriminatory practice in light of the evidence before it and in the best interest of children, rather than on Canada's compliance. Now, my friend made some ado about the remarks about the perspective from which the best interests of children should be considered. And my friends from the interested parties may consider that. And I don't want to spend too much time on this given where we are in my time. But that's an issue that arose between the parties in terms of the meaning of the term best interests of the child and the things that have been done to First Nations children based on whose conception of best interests are at play. Many of the removals involved in the 60 Scoop and Indian residential schools were justified at the time as being in the child's best interest. And so this isn't an example of circular reasoning or logic by the tribunal. This is the tribunal giving voice to a consideration that was put forward in the submissions before it from the First Nations parties to this proceeding, that the best interests of the child can be a hotly contested concept, particularly where we're talking about the intersection of First Nations children with the colonial settler state. And so it's just the perspective that has to be taken given the human rights context in which we're operating. So once again, a key part of the history of the discriminatory practice with respect to Jordan's principle was the continued imposition of limits on whose cases can be considered. And that is what the tribunal was examining when considering whether Canada's conduct had been responsive to the orders. Was Canada continuing to limit access to Jordan's principle or not? At paragraph 117, the tribunal also set its task out as being to examine that responsiveness, the responsiveness of Canada's eligibility criteria to Jordan's principle, including to Jordan's principle's objective previously found by this panel and already mentioned above, and its responsiveness to the panel's orders. And so again, we're in the context where the orders are made, the findings have been found. The question is the approach that Canada is going to take going to further discrimination or not? At paragraph 177, the panel added an important element to this examination. Considering whether using the Indian Act to determine eligibility criteria for Jordan's principle would further or hinder the panel's goal of eliminating discrimination and preventing similar practices from occurring. Of course, this goal is not something the panel has invented for itself. It is the very wording selected by Parliament in setting out the tribunal's remedial jurisdiction under Section 53(2). In setting out the framework, the tribunal referred back to its February 2018 order to explain how it would exercise its retained jurisdiction over the complaint. And it's important to recall that that order was itself an exercise of retained jurisdiction that wasn't challenged by Canada. The panel noted the purpose of its retained jurisdiction was to monitor Canada's implementation of its orders to ensure the patterns of the past were not repeated in its implementation. This function allows the tribunal to make further orders if necessary, such that the parties are not left in the position of starting a new complaint in the event that actions taken by Canada are not sufficient to redress the discrimination found. Now, significantly, the panel also grounded its approach in Jordan's principle, its purpose and its objective. At paragraph 89, it said, Jordan's principle is a human rights principle grounded in substantive equality. The criterion included in the tribunal's definition in 2017 CHRT 14 of providing services above normative standard further substantive equality for First Nations children in focusing on their specific needs, which includes accounting for intergenerational trauma and other important considerations resulting from the discrimination found in the merit decision and other disadvantages such as historical disadvantage they may face. The definition and orders account for First Nations specific needs and unique circumstances. This is important. Jordan's principle's purpose is focused on the specific needs of children, and this informed the tribunal's interpretation in the eligibility decision, as it led it to reject Canada's narrowing of eligibility criteria, and this narrowing caused the exclusion of First Nations children based on assumptions about the obstacles they do or do not face, and not on their specific circumstances. This is a reasonable way of considering a threshold question like this one, as seen in the Supreme Court of Canada's recent decision in Des Hotels. In that case, which was about whether Aboriginal persons residing outside of Canada could qualify as Aboriginal peoples of Canada under Section 35 of the Constitution Act. The Supreme Court of Canada looked to the purpose of Section 35 in order to inform the scope of beneficiaries of the right. And so it can't have been unreasonable reasoning for the tribunal to have proceeded in a similar manner. Now, with respect to the specific reasoning to include First Nations children without Indian Act status living off reserve who are recognized by their nation, this is the first group. The tribunal's reasons moved through a number of considerations to, in its word at paragraph 127, clarify the use of the term all First Nations children. So the tribunal clearly viewed these two groups as posing different questions. The first group, children recognized by their nation, it's were they included in the sense of all First Nations children? And the second, the children with one parent under Section 6.2 required a different legal test. So in considering the first group, the tribunal considered the rights of First Nations to self-determination, and that was at paragraphs 130 to 135, international law, at paragraphs 136 to 157, the new federal legislation regarding child and family services for First Nations, Inuit, and Métis children, youth, and families, and that was at 158 to 164, the Indian Act at 165 to 172, treaties in Section 35 of the Constitution Act at 173 to 198, and the scope of the complaint at 199 to 210. The result of this analysis was an emphasis on the inherent self-determination rights of First Nations to identify their citizens and members, not constrained by the narrow lens of the Indian Act. And in that regard, I just direct your attention to paragraphs 135, 157, 164, 171 to 72, and 175. Now, in light of the time, I'd like to just focus on paragraphs 211 to 228, which provide a concise statement of the tribunal's reasoning process for this group of children. At 211 to 216, the tribunal noted the threshold nature of the consideration and specifically found at paragraph 214 that the lack of an automatic exclusion does not imply automatic inclusion. The First Nations child's needs and circumstances must still be considered in all cases. It's just the question of who gets in the door. At paragraphs 217 to 218, the tribunal notes that determination is within the scope of the complaint, in particular due to Canada's having accepted the tribunal's past orders. At 219 to 226, the panel identifies the limited nature of its determination being made for the purposes of Jordan's principle only, and noted that its orders were imposed only on Canada, and then set out the desirability of input from the parties in establishing the identification process to confirm recognition. And then lastly, paragraphs 227 to 228, the tribunal rejected again Canada's argument that off-reserve services don't form part of the claim. It's hard to see what more Canada could be asking for in terms of meeting Vavilov's requirement of a decision that justifies the outcome to those affected by the decision. Now, in the second branch of the complaint, children with one parent with Section 6.2 status, here also the tribunal followed a clear reasoning process with respect to children with one parent with Section 6.2 status. At paragraphs 231 to 235, the tribunal set out the legal framework for determining whether ameliorative measures to alleviate discrimination are under-inclusive. At 238, the panel affirmed its jurisdiction to consider this question. In particular, and this is important, in particular, given that Canada had only raised the application of the Indian Act to Jordan's principle after the merits decision, and given its prior conclusions, that's the tribunal's prior conclusions about the broad application of Jordan's principle on and off reserve, and to services beyond child and family services, which Canada did not challenge. And the reason I say that's important is that this idea that First Nations identity flows directly from the Indian Act and that the Indian Act is an arbiter of identity, this is a concept that comes from Canada. Canada is the one that has selected this metric for the eligibility criterion. It didn't come from the parties. It didn't come from the tribunal. It didn't come from the House of Commons. And it certainly didn't come from Jordan River Anderson's family or his community, which put forward this principle in the first place. At paragraphs 240 to 252, the tribunal applied the three-part test that it had previously identified at 231 to 235. And then at 253 to 266, it examined and set aside concerns that the Caring Society's motion was a direct challenge to the Indian Act, which of course would have been prohibited given the Supreme Court of Canada's conclusion in 2018 at the end of the Matson litigation. Specifically, the tribunal properly characterized ISK's decision at question as discretionary, and particularly noting that the use of Indian Act status to limit the application of Jordan's principle came not from the statute, but from Canada's own discretion. Crucially, at paragraph 267, the tribunal referred to the need to ensure that its orders did not condone another form of discrimination. This is a key and animating principle throughout the orders below. It is a simple point, but it bears repeating. The tribunal retained jurisdiction to ensure its orders were effective. Its view was that the effectiveness of its orders would be undermined if the orders were implemented in a way that perpetuated further discrimination. This was an interpretation of the tribunal's statutory jurisdiction in implementing the Human Rights Act that was open to the tribunal, and it is owed deference in having chosen it. Now, in terms of that further discrimination, the tribunal noted at least three forms of possible discrimination that would be condoned by Canada's criteria. At paragraph 243, the tribunal presented a hypothetical regarding half-siblings. In this example, a Section 6.2 Indian Act status parent has two children. One child's other parent has Indian Act status, the other does not. The children will have different outcomes of their Jordan's principle request, despite living in the same house. As the tribunal noted, and actually as Justice McTavish, then of this court, noted in the litigation resulting from Canada's motion to strike nearly a decade ago, no other Canadians face these kinds of circumstances. Paragraph 244, the tribunal noted that the total failure to consider real and present historical disadvantage. The tribunal noted that the generational link for this group of children with one Section 6.2 Indian Act status parent, was direct. The issue was not addressing self-identified Indigenous persons with a 12-generation-old link to a First Nations ancestor. Instead, the categorical rule imposed by Canada would mean that even First Nations children with specific needs arising from the legacies of stereotyping, prejudice, colonialism, and displacement, and intergenerational trauma related to residential schools or the 60s scoop would fail to have those needs considered by focal points by virtue of the simple fact that their other parent didn't have Indian Act status. And at 246 to 248, the tribunal noted the evidence related to SJ's case and noted once again that no other children in Canada would be categorized in the way SJ was. This is conduct applying only to First Nations children. So those are the 5 parts of my argument to you this morning, Your Honor. With subject to any questions from the court, those are my submissions.
I don't have any questions at this time because I think it's you've gone through the decision, which I'll also be re-reviewing again, and I think they're consistent with your submissions. I think they track quite consistently with those. I just had that at the outset. It's just the nature of the disputes. Let me just see if there's something from. We've got, just a question about your perspective of the process that's identified to identify people, and it's referenced. I'm not sure if any discussions have occurred in that regard, but what's your understanding of the? Because I know there's different linkages of the compensation decision and this one, but
Your Honor, you've actually reminded me of something that I had meant to address at the outset after the break, and I'm very glad you did. And so the first thing actually I'd like to say is that my friend has actually mischaracterized the result of the impact on the compensation decision, and I'm certain that's just the result of having missed a crucial part of the compensation framework that was agreed to by the parties. And where I'd like to take Your Honor on that, and if you just give me a moment to find it in my joint electronic record. The issue there is that the children who were addressed in 2020 CHRT 20 were actually treated differently by the compensation framework, and that was in recognition of the fact that those children had been subject of a comment from the tribunal that there was no issue of non-compliance due to the uncertainty related to the meaning of all First Nations children in those initial orders. Now, the compensation framework is tab 345 of the joint electronic record, and the specific provision in question is the definition of First Nations child, which is defined in 4.2.5, and I'll just. I believe I'm able to share my screen, but I will attempt to do that. One moment.
So just so that I can find this, I'm unable to find it electronically. But what are you referring to?
So this is the compensation framework agreed to by the parties, and I realize that I've now strayed back into the other judicial review, but it's arising from my friend's submissions, so I subject to your direction. Otherwise, I will continue. And so, do you see on my screen at 4.2.5 First Nations child?
Yes.
Okay, so that is a section that implements essentially the further definition. And so there's the four categories: the registered or eligible to be registered, one parent who is registered or eligible to be registered under the Indian Act. That's the second group of children in 2020 CHRT 20. Recognized by the nation for the purposes of Jordan's principle, that's the first group, and then ordinarily resident on reserve or in a community with a self-government agreement, which is the group that Canada itself added in July of 2018. And the provision here that raises that I wanted to raise with you is the 4.2.5.3, and apologies for the laborious nature of that qualification, which says that children referred to in section 4.2.5b to d, as well as their parents or caregiving grandparents, are eligible for compensation in the amount of $20,000 for pain and suffering pursuant to section 53(2)E of the Canadian Human Rights Act for pain and suffering in relation to denials, gaps, and unreasonable delays with respect to essential services, but are not eligible for compensation under section 53(3) of the Canadian Human Rights Act for willful and reckless discrimination. And so the point there is just that that group of children, my friend's submission was that they were eligible for the statutory maximum, and particularly he objected to eligibility for willful and reckless discrimination. But the compensation framework, which gave effect to the tribunal's orders and which was approved by the tribunal in 2021 CHRT 7, doesn't lead to that result. And this is the document that would govern. So I just wanted to clarify that as a first point. And I thank you very much for reminding me of that, because that was my first order of business coming back from the break. Obviously, my notes were mixed up in front of me. Are there any questions on that, Your Honor, on that portion?
I was just curious. You've answered.
So the other point I just to make is you mentioned the second order and the process. Now I'll leave that to my friends at the Assembly of First Nations and Chiefs of Ontario in particular to cover with respect to the recognition process. My observations on that would just be that it's a process that was developed collaboratively amongst the parties, including Canada, via discussions that were submitted with all parties' agreement to the tribunal for approval. And in the end, again, there's no obligation imposed on a nation to do anything at that point. It is up to nations whether or not they will recognize their children for the purposes of Jordan's Principle. There are mechanisms in the process in terms of how that recognition can be communicated to Canada and by whom, and defaults provided in the event that nations don't set up their own administrative structure. Folks who, by the nature of their position, would be, in a position to or would have the ability to make that confirmation in the government's eyes, and then also a provision where if there's an urgent circumstance and no recognition is forthcoming, the government needs to respond while continuing to make parallel efforts to confirm recognition. So in the Caring Society's submission, that was an appropriate exercise, particularly given the existence of the consultation protocol in this case, and what was submitted on agreement of the parties at the end of that process, roughly 10 months ago last year.
Thank you, Mr. Taylor. I don't have anything further for you.
Thank you very much, Your Honor.
In the interests of, I know my eyes sometimes get a little bit blurry looking at the screen. I'm going to suggest a little bit of a longer break. So I think we can reconvene at 1:30. And hopefully that gives enough time for people to recharge and go for a walk and have some lunch. So see you all at 1:30.
Well noted. The court is now in recess. Thank you.
Recording stopped.